on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This hearing goes from normal to chaotic in seconds. We got Judge Urich on the bench, and let's just say this is not a judge who plays around. He's dealing with a sovereign citizen defendant facing 2 counts of public indecency after allegedly being caught doing something inappropriate in a public park. Yeah, it's that kind of case. But here's where it gets strange. The defendant's behavior in court is all over the place.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Hartwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or...
I've got to say, Judge Urich is extremely good at what he does. I've seen other judges deal with sovereign citizen arguments, and sometimes they either get visibly frustrated or let it drag on way too long. But not here. Judge Urich shuts it down quickly and efficiently. What really stands out is how he calls out the contradictions in their arguments. He doesn't yell. He doesn't overreact. He just calmly points out the flaws. And honestly, the way he does it is low-key kind of hilarious. It's subtle, but it lands every time. And let's talk about that $50,000 bond. Given that this defendant already has multiple felony charges and is still young, that feels like a solid decision. The court clearly isn't comfortable just sending him back out.
If Mr. Stringer wishes to bring various motions before the examining judge and That could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on what is going on right now?
I'm sorry, sir?
I'm being charged. I'm being charged an entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I don't know if you guys caught that in the first hearing, but he literally said, "We're about to go to war," to a judge. That has to be one of the worst things you could possibly say in a courtroom. Statements like that are not taken lightly, especially when you're already facing charges. I'm honestly surprised it didn't immediately turn into a contempt situation. But now things get even more interesting. We're heading into his second hearing, and this time, it's in front of—
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
The living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mont-Lewis, can you prepare an order for competency review?
Do you guys think the competency review judge is making the right call by ordering a mental evaluation? For those who don't know, when a defendant tries to fire their defense attorney, it can raise serious concerns, especially if there are questions about their mental competency. If someone isn't mentally fit to understand the charges against them or assist in their own defense, the court has to pause everything. That's not optional. It's about protecting their constitutional right to a fair trial. Even if this guy thinks he's a legal genius, the real question is whether he actually understands the process, the consequences, and the role of his—
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me
Evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I have a feeling this competency review might come back with some serious findings. This guy has stacked up multiple felony charges, and it doesn't seem like the behavior is slowing down. At some point, you have to ask whether this is just bad decision-making or something deeper. Now, don't get me wrong. I'm all for second chances. People can change. But it starts to feel different when someone keeps cycling through the same kind of trouble over and over again. At the same time, I honestly can't tell what's going on here. Is this genuine mental health instability? Or is it the typical sovereign citizen mindset taken to the extreme, believing the rules don't apply and acting accordingly? And the public indecency charge definitely adds another layer to it. That kind of behavior raises serious questions about judgment and impulse control. As for the judges in this case, I personally think they handled it the right way. They stayed professional, followed procedure, and ordered a competency review instead of reacting emotionally. That's how the system is supposed to work. Would placing him in contempt have changed his attitude? Maybe. Or maybe it would have just escalated things even more. What do you think? Did the judges make the right calls throughout this hearing? Or should they have handled it differently? Drop your thoughts in the comments. If you're into courtroom breakdowns like this, don't forget to like and subscribe. Thanks so much for watching, and I'll see you in the next one.